aspiration, or in the aspirational sense, would imply a very, it's not a permanent state, but an aspirational project of society, and for that matter groups, in order to establish a semblance of harmony. And this harmony, which is again used in terms of the idea of stability. If you look at the work of Samuel Huntington, idea that stability or instability is a function of the kind of balance between political mobilization and level of political institution. So to the extent that you have a level of political mobilization and institutional relations which are in equilibrium, or which in effect attain a particular level of harmony, you can obtain peace, and for that matter stability. So to what extent does autonomy or autonomy arrangement in Northeast India promote durable peace or stability in Northeast India, right? And this, to my mind, can be seen in terms of this argument that autonomy arrangements are likely to recognize and territorially accommodate the self-determination and self-rule claims of tribal groups, and simultaneously foster durable peace and stability in Northeast India under two necessary but insufficient conditions. One is when autonomy arrangement institutionally recognize the distinctive identities and rights of territorially concentrated tribal groups, or for that matter other minority groups, who constitute majority either at the state or sub-state level or both, right? So I think this is critical for minorities or tribal groups to be to be able to be stably accommodated within the institutional framework in the sense in which, if you look at the literature on the politics of recognition that Charles Taylor in effect started as a sophisticated analytical concept, the idea that politics of recognition is central to resolving many of contentious conflict in deeply divided societies around the world is recognized, because if institutional arrangement or institutional practice do not institutionally recognize or accommodate minorities or tribal groups in the way they aspire for, then, as Charles Taylor put it, you can possibly engage in moral oppression or in suppression of the rights of minorities. And when minorities, or in the context of Northeast India, or territorially concentrated tribal group feel that they are oppressed or they are suppressed by the majority group, you would never be able to have a semblance of peace and stability. Right? So institutional recognition, to my mind, is critical in order to foster durable peace and stability, not only in Northeast India, but in other deeply divided places around the world. Secondly, what is also important for autonomy arrangement is that autonomy arrangement have to be negotiated and agreed upon under inclusive democratic setting. If at all these autonomy arrangements were to simultaneously negotiate the self-determination claim and shared sovereignty with and within or across territorially concentrated tribal groups in matters pertaining to identity-preserving powers over land and resources. I think this is very, very important in Northeast India as well as in much part of the world, in many parts of the world, because the kind of autonomy arrangements which are negotiated through various peace accords or treaty or agreements have to be negotiated or have to be settled within a very inclusive democratic setting. And because of the absence of this inclusionary democratic setting, like the one that obtained in the various Bodo Accords, where the non-Bodo majority groups are excluded from the peace agreement, you have a kind of unsettled peace accord, which got unraveled in very complex as well as militant forms. So therefore, I think that it is important. I consider that it is therefore important that such autonomy arrangements ought to be negotiated under inclusive democratic setting, if at all they are capacious enough to negotiate self-determination claims and shared sovereignty, not only with the dominant or majority group which are at the front of negotiating peace accord, but also within and across territorially concentrated groups, maybe tribal or non-tribal groups, in places where their identities cross-cut with one another, right? So these two conditions, I think are necessary, but they are insufficient as they need to be supplemented by robust power sharing arrangement at the center state and sub-state level. And this is one of the critical findings of my research, that despite the fact that autonomy arrangements are either negotiated upon within a semblance of inclusive democratic setting, sometimes not so inclusive, and because the kind of autonomy arrangement that obtained from the peace accords, various peace accords signed in Northeast India, fails to provide, substantive or robust powers or power sharing arrangement between the center and the state, or for that matter, between the state and the sub-state levels, or within or across tribal groups. Many of these so-called peace accords founder, and the result of which is that we have stalemated conflicts and intermittent episodes of instability in Northeast India. So what I try to see this research puzzle and research argument is to situate this within an overarching literature, in fact, which seeks to posit or postulate autonomy not only as an institutional arrangement, but also as a normative idea, which seeks to recognize and address the distinctive needs and claims of individuals and groups, to be recognized as different from their significant others, and to determine their self-interest in their own terms and accord. I think what is important, therefore, to realize in the crafting of autonomous institutions is the normative foundation of those institutional arrangements, which have to fully recognize and address the distinctive needs not only of individuals but also of groups to determine their self-interest in their own terms and accords. Right? So you'll find that if you look at the universe of literature on autonomy or on power sharing in deeply divided societies, you have different types of autonomy which are postulated in order to manage ethnic conflicts, right? So one of the framework within which it is studied, for example, is the framework of which is often called in the literature as integration, and on the other side, accommodation, right? So integration framework often leverage containment and control in places where minorities are considered to be, troubled minorities, which troubled the centripetal trust of the political system. And because of various forms of autonomy demands, ranging from self-determination, self-ruled, to different forms of devolution of powers, there is a tendency on the part of the mainstream political leaders to see this autonomy mobilization by territorially concentrated groups as centrifugalist in their impulse as well as orientation. So for the policy prescription that is often prognosed for this type of mobilization is containment and control. You contain them through a particular form of policy framework which in effect regulate the terms of mobilization as well as demand raised by minorities. Say, for example, in Malaysia, the majoritarian, Malayan, court of the civil as well as, the criminal court, which in effect dictate the way in which the Chinese, and other minorities in Malaysia would behave is considered to be one of the striking exemplar of how some of these majoritarian polities like Malaysia try to contain and control their troublesome minorities. And when this containment and control does not work, in effect, some of these deeply divided polities, in effect, try to prescribe ethnic assimilation as a policy prescription, and when this does not work, to ethnic cleansing, when this does not work, to another extreme form of genocide, partition, and secession. So I think I did not explain on this. On this, so the claim, therefore, on the part of this integration is sometimes autonomy arrangement foster instability. They also foster, some of the building blocks of this integration. If you look at the works of Valerie Burns, Philip Z. Reuters, and other scholars, you'll find that there are enormous concerns of instability as well as disintegration as guiding the policy framework of integration states in different parts of the world. On the other extreme pole, you have accommodationist framework, which in effect runs from array of policy prescription from federalism, which, as Daniel Elazar combines institutional provision of self-rule and shared rule in order to accommodate territorially concentrated minorities. And you have consociationalism. As you know, the idea of consociationalism was developed, given sophisticated analytical treatment by Arjen Lipart, the Dutch political scientist who spent most of his academic career in North America, and who has come up with this fourfold pillar of consociationalism as coalitions of the elites, and you have minority veto, cultural autonomy, and proportional representation in the executive as the hallmark of consociational state. So in deeply segmented societies, according to Arjen Lipart, unless you have a kind of inter-ethnic institutional agreement to foster institutional arrangements which accommodate intersecting as well as conflicting demands through coalitions, through proportionality, through cultural autonomy, or by ensuring minority veto. The problem is that in such pillarized society, you are likely to have violent and bloody ethnic conflicts. Again, multiculturalism, as you know, is an institutional prescription to accord equality of circumstances or equality of respect for all cultures. Territorial pluralism is a term which has been used most recently by Brendan O'Leary, John McGarry, or Carlo Basta, or Richard Simeon and others, to encompass a range of territorial arrangement which would accommodate territorially concentrated minorities. And within this accommodation framework, you'd also have equal rights and representation to all groups, which in effect make up sizable chunk or sizable segment of the population. So what is interesting is that if you juxtapose the two, instead the integration framework would all the time be suspicious about minority mobilization, because they thought that it destabilized or it in effect leveraged instability. On the one hand, on the other hand, accommodation framework would all the time emphasize that timely recognition or timely accommodation of minority aspirations and demands would, instead of leveraging instability or disintegration, promote durable peace and stability. So in these studies, you'll find that the themes of the timing of autonomy arrangement, the form of negotiation or the mode that negotiation take, or the history of conflict, how history of conflict play important part as to whether, for example, self-determination demands precede the crafting of autonomous institution, or whether autonomous institutional crafting, succeed self-determination or popular mobilization are key variables in determining the nature as well as the outcome of those institutional arrangements. So there are also several scholars who also talk about the importance of design of units as to whether a federal polity, or for that matter a polity, unitary or federal, ought to be a kind of dispersely defined in terms of ethnicity, or whether there should be centrally focused ethnicity between two or three principal ethnic bases, territorially organized, and you have different institutional prescription for that, and these are considered to be very important consideration in crafting autonomous institutions. So what you see in the context of Northeast India are what I consider two generation or two broad of studies on the issue of autonomy and how these autonomous institutions in effect play out in terms of the management of ethnic conflict in Northeast India. One broad categories of studies, or one generation of studies, I consider them to be analytical and descriptive single case studies, where insights from disparate case studies are used to either apply or build broader theoretical explanation. If you look at the magisterial work of Sanjeev Barua from 1999, Chobe, S.K. Chobe of Nightingale Politics in Northeast India, Sanjay Borbora, or Jyotirinda Dasgupta, Bithani Lasina, or look at the Dada of your department, Professor Mahanta, or Professor Saikya, Dr. Saikya, Faiz Saikya, and others, Ranbir Samadar, or you look at this breed of scholars whose scholarship is informed by analytical and descriptive single case studies, where insights which they glean from these disparate case studies are used to either apply or build broader theoretical explanations, right? And there are also a host of scholarship or a host of literatures which fall within the second category, which use now increasingly paired case analytical studies with an overarching theoretical framework to explain differential outcomes of autonomy. One of the classic example which I am fascinated with is the study by Sajid Hassan, a former bureaucrat who resigned from his position and subsequently did his PhD from the London School of Economics, come up with this very interesting work on building legitimacy, drawing from the works of Zoe S. Migdal in the African context within the state society model, and trying to explain why you have durable disorder in Manipur or durable peace in Mizoram, looking at state society cohesion or state society lack of cohesion in the states. So these are important studies, but to my mind, these two generations of studies somehow lack to use broad analytical variables to comparatively examine the nature of autonomy arrangement and how those autonomy arrangements have differential institutional outcomes in this place. So my aim in doing this is to bridge this gap in literature and thereby contribute to emerging literature which consider autonomy as a territorial device to manage ethnic conflicts within the accommodation framework. I hope I am going fine with the times. Am I fine?
Yes. Absolutely,
okay.
Absolutely. Yeah.
Okay, so I'll just come to the crux of my article or my paper or research now, which is that in order to explain this, in order to explain the causal relationship between autonomy arrangement and peace and stability, peace and stability as the function of autonomy arrangement, is to come up with these analytical variables, which I categorize it as the explanatory variables or the independent variables and dependent variables. So I am looking at or using two explanatory variables to explain the causal relationship between autonomy arrangement and peace and stability in Northeast India by looking at the history and nature of conflicts, one, and secondly, the timing and mode of negotiation, and are used as the dependent variables that identify preserving powers of the land resources and power sharing arrangement. So using this broad analytical variable, I arrived at these three typology of autonomy. Notice in there I typologize, categorize Nagaland and Mizoram within the homeland state autonomy, and put the various incarnation of autonomy under the six schedule provisions starting from 1952, which are 10 in number now if you exclude Lusai Hills, which has since been upgraded to the Union Territory, and this subsequently promoted to full-fledged statehood since 1986. And evolutionary autonomy which are established outside the framework of the sixth schedule, which in effect was obtained in Tripura between 1950-85, in the hill areas of Manipur from 1972 and 89, and in a different incarnation from 2010 onwards. And you also have 6 autonomous councils for the trained tribals in Assam since 1995. So, just briefly before I look at how my analytical variables play out to draw this distinctive typology, let me explain briefly, what I intend to suggest when I drew up this typology of homeland state autonomy, decentralized autonomy, and evolutionary autonomy.
So if you look at your presentation has got minimized, can you enlarge it? Yeah.
Has it been minimized? Just wait.
Okay, is it my problem? I don't know. But then
no, sir. Even I cannot see it.
Oh, you can't see it.
Yeah. It's
no, that's there, but then it's not like a presentation. Yeah.
So that's why. Let me try again.
Yes, please.
Let me try again.
Okay.
Does it look better?
It's not coming. You have to restart probably.
That's right. Okay. I think I have to start, right?
Yes.
Okay. Sorry about this. Is the disruption sometimes which is caused.
It's very normal. Don't worry. Yeah.
Is it coming now?
Yes, it's coming. Yeah. You live there. Yes. Yes.
Yeah. Looks fine.
Yes, sir.
It's good.
Okay, so look at the summative features of the typology of autonomy in Northeast India that I draw. So homeland state autonomy, in effect, is a form of autonomy which is acceded to a majority tribal group within a particular state, and the consideration of ethnicity is the key driving variable to accede to those autonomy. And homeland state autonomy usually have entrance constitutional provision which safeguard the autonomies on matters pertaining to legislative, financial, as well as executive powers, right? So unlike homeland state, in fact, homeland state autonomy also obtained from a kind of negotiation between a kind of a bilateral negotiation between the central government and the state level groups, and it leveraged a kind of a negotiation mode which is conducted as equals, right? But in decentralized autonomy, unlike homeland state autonomy, one of the marker of this decentralized autonomy is that this autonomy is usually negotiated through multilateral or multi-level negotiation between the center, the state, as well as the sub-state level minority groups. And the result of which is that the mode of negotiation is usually not equal, but as unequals, because, given the fact that the numerical preponderance of the territorial groups are small in number, and given that they do not have the power leverage, and given that you have an asymmetrical power distribution across, you'll find that the mode of negotiation would not be as formidable as you have between the kind of negotiation entered into by proponents of Homeland State autonomy. And what is also interesting is that, like Homeland State autonomy, decentralized autonomy have envisaged or leverage institutional entrenchment or constitutional entrenchment of autonomy, in the sense that you have the sixth schedule provision, which zealously provide for, or which elaborately provide for the kind of autonomy that obtains, despite the fact that you have a very constricted legislative or financial powers when it comes to decentralized autonomy under the sixth schedule of India's constitution. On the other side, you also have devolutionary autonomy, which again are the outcome of unequal negotiation between multi-leveled or multilateral negotiation between different actors, between the central state and the sub-state level political actors. Look at the kind of negotiation that Tripura has, Tripura tribal areas have, or for that matter, Manipur hill areas. And you tend to have that, because these are devolutionary, they are not constitutionally entrenched, but they draw their autonomy from the statutes or laws made by the state. There is element of contingency. There is no element of entrenchment, because they depend upon the political vagaries of the political will of the state level, elite, political elite, and the result of which is that evolutionary autonomy, when compared with decentralized autonomy, is more precarious, more fragile, more weak, not only in the terms of power that are devolved, but also in terms of the constitutional entrenchment, because it depends, as I said, on the statute or the laws made by the state, which are not necessarily inscribed in the constitution of India, and the result of which is that they are far more unstable. So if you look at these typology that I draw by looking at the variables that I use, you'll find that Homeland State autonomy tend to be more robust in the terms of autonomy provisions. Say on the dependent variable that I use on identity preserving power, say for example, you'll find that Homeland State autonomy, like Nagaland under Article 371A, have far more robust as well as expansive autonomy on matters pertaining to land and resources. Nagaland is the only state in India now which has the power to not make applicable laws made by the parliament on matters pertaining to land and resources. Although this, for example, has been deeply contested between 2010 and 2012, when a series of exchange between the central as well as the state government, and I have reinforced the idea that although Article 371A is constitutionally entrenched, there seems to be an element of instability or fragility, given that ours is a centralized federation. So whenever a centralizing impulse can affect capture the minds and imagination of the political elites at the center, the so-called constitutionally entrenched autonomy can also be actually skating on a precarious ground, becomes fully evident in the form of heated political exchange between the central, because the central government, for example, in many of the exchanges with the state government of Nagaland, reinforced the idea that Nagaland's special status under Article 371A is not cast in stone, that Nagaland does not have the fixed power to regulate, say for example, on mines and minerals, including natural gas and petroleum. So if you look at the Mines and Mineral Regulation of 1957, or for that matter, if you look at certain entries in the Union list which give the Parliament the occupied field in mines and mineral, because mines and mineral, including natural gas and petroleum, are resources which are concentrated in land, right? And given that the central government claims this to be the occupied field, notwithstanding the special constitutional provision under Article 371A, there is a fear, for example, across segment of Naga society that this in effect could impinge or could neutralize the constitutionally entrenched special status that Nagaland enjoys. So, so you'll find that when you compare the status of Nagaland vis-a-vis on identity-preserving powers with decentralized autonomy or devolutionary autonomy, you'll find that they pale into insignificance, especially the sixth schedule autonomy on identity-preserving powers is in effect constricted to actual use of land ownership, and they do not have the power to transfer land, to other entities. It is the state which has the sole plenary power and the prerogative to regulate on transfer of lands in tribal areas in the six settled areas, right? So this is a case which is confirmed by the Supreme Court in the famous Sitimon case. Sitimon Sawain case in 1973, whereby it says that the district council, autonomous district council, and the six settled do not have the plenary power to regulate or to legislate on transfer of land and property, but its power is delimited to actual use of ownership and not to transfer of power by giving the plenary power to the state exclusively. So in that sense, decentralized autonomy pale into significance when you compare with, say, the identity-preserving power of this autonomy model, right? And in the evolutionary autonomy model, like the hill areas of Manipur, for example, for identity-preserving powers, it has very inconsequential powers because the hill areas committee, which is established under Article 3721C of India's constitution, and the district council, 6th district council in Northeast, in tribal hill areas in Manipur, in effect simply have advisory powers, and the advice is not binding upon the state government. And the state government has tried to manipulate this precarious position by superimposing a series of land reforms to neutralize the kind of protective mechanism that the hill areas have under the chieftaincy. So these properties of autonomy, or these outcomes, institutional outcomes of autonomy, could be seen to be the result of the explanatory variables that I use, which is that the nature and history of conflict for self-determination. So if you look at these three models of autonomy and compare them in terms of the nature and history of conflict for self-determination, you'll find that Nagaland and Mizoram have witnessed the most prolonged and the most protracted struggle for self-determination. At one point of time, explicit declaration for sovereignty, Nagaland in 1955, Mizoram in 1966, and they have embarked upon a very prolonged, sustained popular movement for autonomy. And in this homeland state autonomy, the pivot, the central driving force of this autonomy is protection of land and resources. In the context of Nagaland, for example, because the idea of Ura Uvi, our land is ours, which, Angami Zakufi, so, the tallest leader of the Naga National Council, in effect, had tried to reinforce again and again, considering that land and resources are not only the central pillar of Naga identity and sovereignty, they are in effect reinforcing the sense of Naga identity as well as sovereignty. So land and resources are central to Naga nationalist project. And because they are central, they have been able to somehow negotiate very forcefully with the government of India when they entered eventually into what is often known in the literature as the 16-point agreement, right? So whether it is the 16-point agreement of July 1960 or whether it is the Akbar-Hidari agreement of 1947, you'll find that there has been very powerful motive on the part of these armed as well as independentists or accommodationist Nagas to negotiate, and there is no compromise whatsoever on Naga sovereign claims on land and resources. And because land and resources are central pillar of Naga's movement, you'll find that in terms of its effect or in terms of its outcome, you have a more robust identity preserving powers that this homeland state autonomy entails. On the other hand, you look at decentralized autonomy movement. In effect, although you have a brief movement for autonomy, in fact, there are steerings of autonomy in the hill areas of Northeast India when the Borderline Committee, in effect, visited the hill areas of Assam, then hill areas of Assam in 1948, in the summer of 1948. They were steering of demands for self-rule, which they thought could be somehow accommodated within the framework of some semblance of the sixth schedule or some form of internal self-determination, right? And look at the case of the Bodos, for example, the idea of identity and resources, although would come sometimes as a supplementary motif of the overarching demand of Bodo elites for access to power, for linguistic protection, as well as cultural preservation of Bodo identity, has never been central to their sub-nationalist mobilization. And the result of which is that you have a far weaker form of autonomy. In fact, land and resources are very inconsequential in Bodoland areas, and for that matter, they are not so robust in terms of the constitutional protection in the six settled areas. Again, as I have said, because there is no history of popular and sustained movement for self-determination, what you have is that you do not have. It is marked by a conspicuous, or timid form of negotiation or no negotiation at all in devolutionary autonomy spaces in Northeast India. Another thing which I think is also very important and which has important bearings on the nature or on the outcome of autonomy is the timing and mode of negotiation. So you'll find that homeland state autonomy are foregrounded by timely negotiation of autonomy, which sometimes predates popular self-determination. When I say this, I say with a qualification, say, for example, in the case of Nagaland, you have the formation of the NNC in 1946, but the NNC in 1946 was not yet a popular movement. It became a popular movement in the limited sense of the term that you might like to use it, since the NNC, hold the plebiscite and use this popular motif as well as popular symbolism as well as emotional support to rally the demand for self-determination or sovereignty. So, in order to forestall this self-determination movement, you have the Akbar-Hidari Agreement, which was reached in 1947. But, and of course, as this Akbar-Hidari Agreement has founders on a conflicting interpretation of the ninth clause of the 9-point agreement, you have a stalemated conflict, and the result of which is that in the state of insecurity, fear, and large-scale violence, you have the July 1916 point agreement, which in effect laid down the foundation of integration of Naga inhabited territories or integration of districts, Sibsagar or Nagong in Assam, which has been a recurring demand, a point of contention between Nagaland and Assam till today, or for that matter, having endowed or envisioned a more robust protection when it comes to land and resources. So you'll find that timely negotiation or the mode of negotiation when conducted through a bilateral mode or through a mechanism which in effect leverage the actors as equals, in effect seems to have more favorable outcomes when it comes to autonomy outcomes. So the NNC on the one side in the 1950s and subsequently the Naga People's Convention and the NSC and on the today, on the background have been somehow negotiating with the Indian state, although you might consider that they are negotiating not as unequal but as unequal. There is a kind of a semblance of equality in the sense that the Indian state, for example, continue to recognize NSC and IM alongside today now, which again is one of the complex unraveling of the peace accord, because when you open up to a more inclusive democratic setting, you would also change the nature and format of the mode of negotiation from one of being equals to one of being unequal partnership, and the result of which is that the kind of outcome might gradually or unintentionally get weakened over years. So the result of which is that sometimes timely negotiation helped, and bilateral negotiation also helped in terms of a more decisive, policy outcomes when it comes to peace negotiation. So, however, you may, however, nuance this in the context of six scheduled areas. You may argue that if timely negotiation is responsible for a more robust autonomy arrangement with respect to Nagaland and Mizoram, why not the same obtained in the case of these six scheduled areas? This is a plausible point because, as I already said, this by itself is not sufficient. It has to be supplemented by another explanatory variable, which is the nature and issue of conflict. And unlike homeland state autonomy spaces in Nagaland and Mizoram, the decentralized autonomy space in the six scheduled areas are marked by a very limited, brief movement for self-determination. And the kind of self-determination, internal self-determination that obtained in Bodoland at one point of time under the NSF and subsequently under the National Democratic Front of Bodoland, which has now been brought into the negotiating table, and finally you have the latest edition of the Bodo Accord in 2020. In effect, came much after the initial stage of negotiation had been conclusively drawn, and the result of which is that because of this brief and lack of sustained popular movement, you have sustained popular movement which are non-violent in nature. You have a rather weak autonomy arrangement. So this can also be seen in terms of the properties of powers which are given to these autonomies, right? In Nagaland, in Mizoram, you have 62 subjects which are entrenched in the constitution like most other Indian states. And over and above this, you have very important powers under Article 371A on land and resources, matters pertaining to customary laws, religious practice, so on and so forth. But in decentralized autonomy spaces, you have some form of arrangement for legislative, executive, financial powers. But in terms of a very key important variable of identity preserving powers, the power of BTC, for example, on land resources, or the power of the Garo Autonomous District Council, Zainted Autonomous District Council, or you name it, any form of one of the 10 Autonomous District Council have very inconsequential powers on matters pertaining to land and resources, right? So what is therefore interesting is also to see how these autonomy which are constitutionally entrenched have differential impact, right? In terms of peace and stability, you'll find that in homeland state autonomy, you tend to have enduring violent conflicts, ceasefire, despite the any issue.
No, Professor Hausing, I'll request you, and the discussion is becoming so interesting.
Yeah.
A lot of questions are also coming.
Yeah.
Therefore, you can, if you can complete the presentation maybe by 5 minutes, then you can also address, you can see in the chat box, a lot of very interesting questions are coming. So we do not want to miss them also.
I'll come to that. I'll just conclude in 2 minutes, not 5 minutes.
Okay, thank you very much. Thank you.
Okay, so you'll find that because the mode of negotiation in the homeland state autonomy model is such that initially, although it was a bilateral mode of negotiation happened, and subsequently with the splintering of Naga armed groups, you have a more splinter groups which entered into the negotiating table, and the result of which is that the negotiating mode become more fragmented, more unequal, and it has in effect, instead of brokering a decisive peace, would in effect ensure that it does not ensure durable peace. And this is also drawn from the fact that the kind of autonomy envisaged for Nagaland and Mizoram, for example, do not amount to full institutional recognition of self-determination claims. Right? There is initial hesitance or reluctance on the part of the Indian state to recognize Naga mobilization for self-determination, because they see that these are like contingent corollary of law and order problem. They are not political in nature, and they can effectively be dealt with extraordinary laws like the Armed Forces Special Powers Act. It has in effect spawned enduring as well as stalemated conflicts. So despite this ceasefire agreement, the fragmenting nature of the negotiation and the reluctance of the Indian state to fully recognize Naga self-determination claims, in effect, foster stalemated as well as enduring conflicts for Nagaland. And for autonomy provisions for in the decentralized spaces, decentralized autonomy spaces in the sixth schedule, you'd also have recurring cycles of peace and instability, because, for example, in Bodoland, one of the conspicuous region for generating recurrent cycle of peace and of instability is the fact that the non-Bodos had been totally excluded from the peace negotiation, right? And by envisioning, say, for example, in the 2003 agreement, of just 5 seats for the non-Bodo groups, and reserving thus around very minimal number of seats for this, which are also susceptible to being manipulation by the Bodo groups. You have the rise of non-Bodo, which continue to play a very important part in derailing the peace process. And the result of which is that you have counter-ethnic or counter-tribal mobilization against the Bodos, which have in effect spawned intermittent cycles of conflict as well as instability. Right? In Manipur or in Tripura, and for that matter in the plain areas, you would also have intermittent violent conflict depending upon the majoritarian impulse of those state government, which are seen by minority tribal groups, although they constitute the majority in their geographical location, as engaging in majoritarian impulse. For example, the clearest example of which is the 3 bills that was passed in Manipur in 2015, which was seen by the tribal Hill people as another attempt, to kind of neutralize the protection that they have on land and identity. So when you have such majoritarian impulse, you have counter-tribal mobilization, which in fact spawned a series of conflict and contestation about policies. This is about it. In fact, I have more to say. I can take a number of hours spelling out, but I hope this provides a good ground for us to discuss and converse, engage in conversation now. So, Akhilda, you want me to read directly and respond, or would you like?
Yes. So, I think there are some questions which have already been written in the chat box. I think some of us can moderate it so that it doesn't become a problem for you. I think my colleague Vikas is there, Vikas Tripathi, my colleague from the department. If Vikas can moderate this question hour session, that would be great. And some others will directly raise questions to you. Not necessarily they are writing in the chat box. But before we move to the interactive sessions, I'll take 1-2 minutes, to express our gratitude for such a comprehensive and insightful discussion. The way you have talked about autonomy and territorial arrangement or management, looking into the very diverse dynamics and techniques and fallouts, it has enlarged our understanding and understanding and insights about the very complexities involved into the process of autonomy and assertion, and the state and both the constitutional arrangement and state processes handling them. Therefore, this has been really very insightful for all of us, and I, on behalf of the department, thank you very much. I have a question. So, before Vikas moderates it, very simple question. You have talked about three typologies of autonomy: state model, autonomy model, and then devolutionary model. But what about the framework agreement, which has also gone beyond it? Beyond state model, talking in terms of shared sovereignty kind of thing. So, how do you look at that? So, he'll address that question, and I also request Vikas to take over. Over to Vikas.
Yeah, should I respond first, or should we?
Yes, you may.
Okay, thank you, Akilda, for that question. You see, if you look at the effects that I draw, in effect, you be categorized within the accommodation framework. The homeland state autonomy model and the decentralized autonomy model. Accommodation is in terms of the impulse as well as in terms of the effect, right? So, despite the fact that the Naga independentists, for example, continually contest the 16-point agreement, which S.C. Zamir and others consider it as the bedrock of Naga society. In effect, to my mind, this is possibly the best way for Naga independentists to realize or to work on their future contour of sovereignty, which might, in effect, be negotiated or may even be shared in whichever direction or whichever forms that you might like to envisage. So the framework agreement, which in effect talks about, for example, the special federal relationship between the Nagas and the Indians in terms of, acceding to the Nagas' core or cardinal demands, like a separate constitution, a separate Naga flag, for example, are possibly to be accommodated within this accommodation framework, right? So to the extent that Indian state is flexible and innovative enough in allowing, in the form of Article 370 vis-a-vis the state of Jammu and Kashmir, now that you have a very integrationist political party at the helm of affairs at the central government, it is a different dispensation altogether. But it seems that Article 370, which envisages a special constitution from Jammu and Kashmir, does not in any way violate, the basic structure of India's federal constitution. If we imaginatively apply the Indian constitution and allow it to be flexible and dynamic enough to form to embark upon a provision within the constitution, which the Nagas claim themselves as their own distinctive characters. I think one of the ways has already been there in the blueprint. Article 371A, to my mind, is already a mini constitution in itself if you look at it very closely. So if you look at my article, for example, you'll find that if you look at the original Article 371A, Article 371 is an asymmetrical arrangement not only between the central and the state government of Nagaland, it is also giving enough asymmetrical arrangement within Nagaland itself. Remember that the Tuensang area has its own asymmetric arrangement in the form of giving them the filter legislative mechanism whereby, the Tuensang areas, which before it was dismembered into 4 districts. We have considerable proliferation of district in the Eastern Nagaland, which now become the fortress of demand for frontier, a separate frontier Nagaland state. In effect, it is because of this satisfaction of these 6 backward tribes in the 5 backward district of Nagaland that the internal asymmetrical arrangement had been violated. Remember that Nagaland had an internal asymmetry by providing regional committee system from 1963 to 1974, and these so-called backward districts had been given representation by 6 MLAs, which was increased to 12 MLAs. Subsequently, it has been further increased. The 5 backward district now send something like 24 members of the Legislative Assembly. They have also the power to kind of veto, pen state level legislation at the state level. So, if we take this as a blueprint for a distinctive Naga constitution, incorporate and elaborate it further to attenuate to or to accommodate the distinctive claims and demands of Naga independentists, I think what is central to the Naga nationalist mobilization, as I said, is the identity preserving powers on land and resources. Land and resources had already been inviolable part of Indian constitution, but subjected to the vagaries of centralist federal impulse. But if this is made as basic structure of Indian constitution and become more robust, I think if Nagas have control over their land and resources, which is the springboard of the identity and sovereignty, I think this is it, right? This is about it. If they have the full power to regulate, and I think this is something which the Naga independentists have to creatively engage and negotiate it upon to broaden it and give final blueprint in the separate constitution that they demand. I think this is possible, but only when the central level political leaders are creative or innovative enough in tweaking existing constitutional arrangements.
Okay, thank you very much. Over to Vikas.
Okay, thank you so much, Akhilda. I think we have a lot of questions and we cannot take all of them considering the constraint of time. So I'll try to pick up 3 questions because it's already 15 past 2. So the first question is, sir, despite having autonomous power in Northeast India, specifically 6th scheduled area, why they can't establish their own laws and they have to depend on state or central government? But why, sir? This is a...
Okay, I think the question has to be nuanced in the sense that... Yeah, the question has to be nuanced in the sense that to a certain extent you may say that despite autonomy provision and the 6th scheduled, autonomous district council and the 6th schedule do not have the power to make laws. And the clearest example is the Sitimon Sawain case that I have just spelled out. So in terms of the power to legislate or to make laws on transfer of property, the autonomous district council do not have the power. But in terms of regulating, the laws, they do have. And there is something called legal pluralism in Indian constitution. In fact, the Indian constitution, in effect, accept the principle of legal pluralism in the sense that as a matter of primacy or as a matter of first preference, whenever issues pertaining to marriage, divorce, or inheritance of property, or even succession of headship or chieftainship, which are within the ambit of the 6 scheduled areas, which are within the ambit of the powers of the district council, you'll find that the courts would not preemptorily intervene in those affairs. It would allow traditional institutions to negotiate and to broker a solution for those. But when they could not be settled within the confine of customary practices, they do come to the High Court and subsequently to the Supreme Court. So, as a matter of preference or as a matter of primacy, customary laws are privileged. But to the extent that sometimes customary laws, which are very well within the powers of the district councils in the 6 areas, they, in effect, so long as they cannot, settle the issues very amicably, they invariably go to the High Court and subsequently to the Supreme Court. So it would be a partial interpretation to say that 6 settled areas are deprived of legislative power. They do have. They have constricted legislative powers, especially on matters pertaining to divorce, on marriage, on inheritance of property, on succession of chiefs, so on and so forth. But they do not have the plenary legislative powers on matter pertaining to, say, for example, transfer of property or transfer of land.
Okay. We have one question from our research scholar, Gracie. I think most of the answers have already been responded to in the presentation, and while others are not very relevant for the discussion, I'll take one last question from Gracie, though I think it is also kind of responded in the presentation. But let's take one last question by Gracie. Sir, what are the standards through which we can measure the intensity of strong and weak power arrangements derived from this institutional device of territorial autonomy spaces? Do you, in the same line, study the typology of power arrangements also as you did with the autonomy?
As you rightly pointed out, because I think the answer to this question is already implicit in the article. So you'll find that these 3 autonomy models envisage or entailed differential power sharing arrangement, right? As I have already pointed out. But what is the commonality across these 3 power sharing arrangement across the 3 typology of autonomy is that unlike Homeland State autonomy model, which seems to have more robust powers, given that 62 number of subjects have been devolved to the state of Nagaland and Mizoram, like most other Indian states, and over and above that, they have more robust powers when it comes to land and resources, especially in the case of Nagaland under Article 371A. But in terms of, say, for example, the power sharing arrangement, you'll find that in Nagaland, as I have pointed out, initially the Twins and backward areas have been given a special cabinet representation. From 6, their representation has been increased to 12, and now they have been expanded further to 24. So in terms of the state level power arrangement, the state autonomy, Homeland State autonomy model seems to have more robust powers, right? But in terms of the internal dynamics of sharing of powers, they seems to be lacking, and that is precisely where the 6 backward tribes in the 5 backward districts of Nagaland had been demanding that they had been given insignificant proportional representation, say for example in grade 1 position. Say for example, out of some 9,000 or grade 1 or class 1 gazetted officers in Nagaland, they hardly have around something like 800, so which is considered to be abysmally poor and unimpressive, right? So when we talk about powers at the decentralized autonomy level, you'll find that it varies across. The highest or the most empowered autonomy under the decentralized model is the Bodoland Territorial Council, which is something like more than 40 subjects being transferred, including the power to the municipal council, to public works department, so and so forth, which are seldom given to other autonomous district council and the district settled areas. So you have from around 17 subjects to around more than 40 subjects transferred under this decentralized autonomy model. But what is also very interesting in this decentralized autonomy model is the conspicuous weak power sharing provision, whereby minority tribes within these 6 schedule areas in these district councils are very insignificant. Okay, they will be given from say 2 to 4 nominated positions, which sometimes are even manipulated by the majority or dominant tribal groups within those autonomous district councils. And that is precisely where I thought that the very interesting lesson from this power sharing model comes not so much from Nagaland or from the 6 settled areas, but from the Rabah Council. In fact, if you look at, you'll find a more proportionate distribution of seats for various groups within the Rabah, autonomous councils, which suggests that a more level playing field in terms of participation or representational politics is envisioned within those council arrangements, although they are not very consequential in terms of their power to leverage identity powering, identity preserving powers of land resources, for example, although they are mostly developmental essences. So you'll find that there are, kind of subtle differences, but the pattern it obtains, except the Rabah Council, Rabah Autonomous Council in these areas, is that you do not simply have a kind of a robust, a more proportionate power sharing mechanism in place. Tribal elites themselves tends to corner most of the benefit that flows from power, and they realize that, and they do not share power. And I think this is one of the important lacunae in these autonomy models across the three models, which in effect spawned stalemated conflicts and instability from time to time.